Good morning, it's April 30th. We are taking up page 937 with a few amendments. We have Ledge Council here to give us the walk on that. So, floor is the leaders.
Good morning, Judiciary News for the Office of Legislative Counsel. This is draft 3.1 of H 937. These are all of the instances in which this committee is amending this money's Judiciary bill. So the one that I'm set to talk about today is the one that I described yesterday, and it's just the language. So go through to page 3. The language starts with section 40C. The language starts on line 13 on page 3 and runs to on page 4 line 5. So they mentioned yesterday it's related to H 849 and in conversations with the Attorney General's office. We think there could be an ambiguity that it's easy enough to avoid by clarifying this. So the suggestion was that it couldn't hurt to do that in this instance of amendment. So a reminder that this is about when there is a suit against a state employee, what happens and how the state steps in to defend and or to indemnify and pay money would be ordered paid as a result of an employee's actions within the scope of their employment. Yes. So the small change to clarify is on page 19, or sorry, line 19 on page 3. So this section talks about the fact that where someone is bringing a suit under 42 U.S.C. section 1983, which, as you'll remember, is the federal statute that the cause of action in H 849 is based on, that there are liability caps that apply. So the state will only pay out so much money if those suits are ultimately successful in judgment. And it just clarifies that just like with section 1983, those caps would apply to an action under an action like H 849. So it adds that in any action defended by the AG in which judgment is rendered against an employee of the state for acts or omissions within the scope of his or her, that is a little typo. So we'll tweak that, but that should say within the scope of his or her employment. We generally are replacing gendered pronouns with non-gendered language, but that is a typo that I will fix. Within the scope of his or her employment or a settlement requires payment by such a person, and the right of action is based upon 42 U.S.C. section 1983 or a similar state statute, or under a similar federal statute where state law is incapable of establishing an employee immunity, the state shall indemnify the employee for the amount of employee's liability. So that's how it works currently. How it applies to laws like section 1983 and under subsection B. So this is page 4, lines 3 through 5. The maximum liability of the state is $500,000 to any one person, or maximum aggregate liability $2 million to all persons arising from these. So this clarifies that just like laws currently, like section 1983, this cap applies, that H 849 is indeed one of those laws.
Any questions?
The general could just civil and criminal.
Just civil.
Just civil.
Yep. So that's part of these kinds of statutes. Section 1983, the cause of action created in H 849, or a similar federal statute. I'm unaware under case law what those other statutes are, but we are in the civil realm.
Thank you.
Do we have any issues or questions about these amendments? Are we good with them? You had an amendment you mentioned you wanted to bring.
I do. Do you by chance have a copy of it with you?
I do.
I can hand it over. I will, does someone, I actually know what it is.
Is this the one that the Human Rights Commission asked?
It is the one for the Human Rights Commission that's for. Emery, do you have a copy or do I need to get you one? Can I get you a copy?
I'm also happy to pull it up on the screen if that's.
That might make the most sense, given that we don't have immediate copies available.
Emery, would you just mind sharing the Zoom link?
Sorry about that.
And
I
I'm
sent it
also
to you.
sending me this Hillary's documents.
Thank you.
So by way of sort of context, there's sort of two primary ways that investigations of discrimination happen within the Human Rights Commission. One way is that an individual, so for example, I say, I think my landlord discriminated against me, and it goes through the process, and the Human Rights Commission has capacity and finds cause, and they would implement or begin an investigation. The other way is that the Human Rights Commission sees something that they believe might be systemic discrimination, and they start an investigation, not on behalf of an individual, but sort of on behalf of the Human Rights Commission and on behalf of people generally. And an instance of that might be the Human Rights Commission feels like maybe the way the DMV is issuing driver's licenses is discriminatory. And so they're not investigating an individual person, they're investigating the whole process. And there's some ambiguity currently about when the results remain private. And so this clarifies that in an instance when the Human Rights Commission starts an investigation of that type of systemic discrimination, that the results of that will be made public. And it really is around transparency. When we're investigating our government, the public has a right to know what the outcome is. Whereas when we're investigating an individual instance, there's a privacy aspect. So it doesn't touch that. It still allows that to remain private, to protect both the person who might have complained and the person who was being investigated. But in an instance when it's looking at a larger systemic governmental issue, it clarifies that in those instances, the results will be made public. So we know, is the DMV discriminating or are they not?
So is this something? So would it be like somebody making a public records request, or and then the information is made public or shared with them, or is it the Human Rights Commission just posting on some pages?
So the Human Rights Commission would make it public at the completion. If there are individual names named in the investigation, they can be redacted to protect that individual's privacy interest. So it would be sort of the process and the results are made public. Certainly, I would also imagine that if someone made a public records request, they would be available to them. But I would also let legislative counsel tell me if I'm right.
I think you're correct. My understanding is that. So a little bit of the context. There are a number of different kinds of records that the Human Rights Commission has in the course of its investigations. There's a complaint. There can be an investigative file, just like all of the interviews and documents they get. There's an investigative report, which the commission staff compiles with a recommendation based on their investigation. Either a recommendation that there is grounds to believe that discrimination occurred or not. Then the commission itself reviews that. Parties have a chance to respond to that investigative report, and the commission issues a final determination. So under current law, complaints, investigative files are confidential, period. Final determinations can be made public if the commission finds there was reasonable grounds to believe discrimination occurred. So if the commission finds the basis to think there was discrimination, then the final determination can be made public, and that includes the individual's names. If the commission does not find that there was reasonable grounds to think discrimination occurred, the individual names cannot be shared, and the final determination is not shared. So there has been some litigation. There's a Second Circuit case about investigative reports. If you're following closely, I listed that in my first list and didn't in my second. So the Second Circuit thinks it's ambiguous under the current statute whether an investigative report is a complaint and investigative file that has to be confidential or not. So this clarifies, at least for purposes of an investigation started by the Human Rights Commission, with the Human Rights Commission initiated complaint, the investigative report can be made public or has to be made public. And that could be either through the commission publicizing it. They do a variety of educational and other activities in addition to their investigations. So it could be in the course of that work, or it could be through a public record.
And again, this is only in the instance when there is not a person that is the individual complainant. It is the Human Rights Commission that is investigating a bigger systemic issue, probably within sort of our governmental entities, or like the other instance I can see this happening would be where it would not be a governmental entity, would be if the Human Rights Commission, say, investigated the University of Vermont, but they're still sort of providing a public good.
I'll defer to, I think, Vic Hartman will be coming in. I'll defer to them in describing kind of the difference between their individual complaint, the Human Rights Commission individual complaints, and the ones that the commission staff files. Under the statute, the difference is that any private person can file a complaint. The commission has no way to know until they start investigating whether that has a basis or not at all. If a Human Rights Commission staff has essentially a prima facie case that discrimination occurred, that's the statutory requirement for a commission employee to initiate a complaint. So essentially, when the investigation starts with the Human Rights Commission initiated complaint, there is already some basis to investigate there, because they have to find that there was a prima facie case of discrimination. And if you have more questions about what a prima facie case of discrimination is, I will defer to the Commission Executive Director for examples.
Okay. Makes sense. I don't have any issue or questions. It's not, I guess my only question will be whether this is public after a public records request, or if it's as a rule of procedure, the HRC is just going to publish on some website every single report. I mean, mainly the curiosity aspect of it would be. Yeah, so that's a question I'll save for Big a bit later on.
So I tried to, in some degree, it's not in this amendment, but when I started this amendment, in some way, I tried to sort of answer that question by actually creating a sort of registry where they would put things, but they felt like that at this point was a much bigger lift than belonged in the miscellaneous bill. So we took it out of the amendment to work on at a future time. And that's how the Criminal Justice Council puts their stuff forward, is they have a registry. You can go search. Some of it is like not super public. It just sort of says like, here's the complaint number. This is what happened. There's no names. But if those claims were substantiated, that's not the word that I want, but I think you know what I mean. Then based on the law, those things are made more public. And so initially part of this amendment was to do something similar, but that felt like a much bigger lift than just sort of clarifying a kind of technical-ish clarification. So I had the same thought and question that I tried to answer, but we're too late in the session to do it now.
Yeah, so I'm really not sure what we're trying to accomplish here. My question is, so this is after the Human Rights Commission has done their investigation, and they have come up with a decision as to whether it's discriminatory or not. Even before being brought to a court or whatever else, this information will be made public.
As currently drafted, yes, after the commission.
Before they even go to court, or
so the executive director will be able to describe this much better than I can,
Okay.
but my general understanding is that there are a number of steps in a Human Rights Commission seeking to enforce civil rights laws and anti-discrimination laws. So they might try to mediate or settle early on. If they continue through to an investigation and the commission reaches a determination, there's another chance to mediate and settle and reach an agreement. It can eventually go to court. But this just pertains to the Human Rights Commission process. And it would be, essentially at the end of that process, after the commission is reached. But you're right that, for cases that could end up, going to court, this would be happening before that. But more details on that for two.
I think also to that question, Senator Norris, there was, Hillary, you had mentioned earlier, a Second Circuit decision that said the public records laws in some way were ambiguous for the Human Rights Commission. I'm just trying to clarify that.
This does in part. So if you'll look right here, this is the key language we're talking about. Except as provided in this subsection, the Human Rights Commission's complaint files and investigative files shall be confidential. Complaint files and investigative files pretty clearly covers a complaint. Definitely covers the investigative file, which is kind of the bucket of everything they gather in the investigation. But in the Human Rights Commission rules, an investigative report is listed separately from these things. And the statute is currently drafted, doesn't talk about investigative reports, doesn't use that term. And so the Second Circuit said, not clear to us if an investigative report is a complaint file, investigative file that has to be kept confidential under the statute, or whether it is something else. This is for this language here in A1. This is for all complaints. So this means that for complaints filed by private persons and for complaints initiated by the Human Rights Commission, complaint files and investigative files shall be confidential. The change made with this proposed language does not apply to investigative reports that are based on an investigation, based on a complaint by a private person. So it's not entirely resolving the Second Circuit ambiguity, which was all investigative reports. They weren't clear what the statute said about whether they had to be confidential or not. This only clarifies that for an investigative report based on a Human Rights Commission initiated complaint, it shall be made public. And it maintains the kind of same redaction or protections that is in the current law, in the sense that under the current law, as I mentioned, the only way that the parties' identities are shared is if the commission reaches the final determination that there was reasonable grounds to believe discrimination occurred. As drafted, unless the commission finds reasonable grounds, the identities of the parties are not shared. The names and identities of the parties are not shared. There are also two other redactions in current law, or kind of exceptions in current law, that are protections for information that should not be disclosed, and that's carried over too. So in current law, the Human Rights Commission, when we're talking about an investigative file, the party being investigated can request some of what's in there because they're trying to respond to it, describe what happened. They are allowed to request what's in there. The Human Rights Commission, as described, makes it available, except they can not share or redact the identities of non-party witnesses to the investigation if good cause is shown to protect the witness's confidentiality. There might be a good reason why a non-party witness doesn't want their identity to be known or shouldn't be made known to the person being investigated. Or the commission also can refuse to disclose records or information, the release of which may be prohibited under state or federal law absent court order. It's a little bit of a mouthful, but it essentially says if there are other protections in law for that kind of information, so it could be like personally identifying information that's otherwise protected, then that is another category that doesn't get disclosed. Those categories carry over to the investigative report. So the investigative report can be shared, or shall be shared, but the commission shall not disclose the identities of non-party witnesses to the investigation if good cause is shown to protect the witness's confidentiality, or information the release of which may be prohibited under state or federal law absent court order. So if there's some other protection in law for that information that prevents it from being disclosed, this doesn't authorize the investigative report to disclose it. And then C is the one we talked about, that the only way the identity of the parties and any information that would identify the parties can be disclosed is if the commission finds that there are reasonable grounds to believe that discrimination occurred.
That there are, or it says no reasonable grounds.
I was also catching that, but I'm not sure if it was because I was describing the statutory language. Yeah, so this says, this is the danger of me not reading the language exactly, but it's a good thing to confirm. So, except that the commission shall not disclose the identity of the parties and any information that would identify the parties if the commission finds that there are no reasonable grounds to believe that discrimination occurred. So my paraphrase led you astray, but the language is correct that if the commission finds there aren't reasonable grounds, you cannot share the identity of the parties and any information that would identify the parties. Any other questions about the exceptions? I think the one other thing, part of the language that hasn't been mentioned so far, this is page 3, a section in session law for application to pending investigations. When a statutory change happens, if there are kind of ongoing matters it could pertain to, it's helpful if the legislation says what's supposed to happen with what's pending or ongoing when the law takes effect. And so this proposed language would apply the act to any pending investigations by the Human Rights Commission. So the Human Rights Commission had an open investigation when this act takes effect. These confidentiality and disclosure provisions would apply.
Anything else? I'm good with it. We're gonna hear from Big, I think at 10 or 10:15 and then we have any questions there. So unless there's any objection or any other discussion, I'd like to add it to the list of amendments, miscellaneous bill. Is there more?
It's such as I stated earlier, my only concern is this, I don't care if I want to release the name, but you've got a commission who has made their determination. And even prior to going to court where this person could be absolved in this, they're going to release all this information. I just seems, it kind of strikes me the wrong way.
It's
That's all I'm saying.
my understanding, it's investigations into organizations, not individual people.
I'm not sure that that's the case.
Okay.
At least under the statute, I think. It can be any violation of anti-discrimination or civil rights laws. There might be a practice at the Human Rights Commission of when they choose to have an employee file a complaint, and kind of standards related to that, but that's not something that's in the statute or that I can speak to, but might be a good question for
If there's no finding, but under this, if there's no finding that discrimination occurred, the identity is confidential.
correct. The investigative report can be shared, but the scroll back up to the language. The identity of the parties and any information that would identify the parties information.
I mean, I have an issue with the government being transparent about what the government's doing. So. Yeah. Okay. Any other questions or issues? No? Okay. All right. I do have a much less substantial request. I think there was a typo on page 10, line 1, as passed by the House.
Which bill are we on?
As passed 937. It says any affirmation action taken by the board.
On this, I will defer to my closet top.
Oh.
Not to pass the buck, but She will be better able to answer your questions.
So you said page 10.
Page 10, line 1, it says any affirmation action taken by an obligor.
Oh, right, affirmative.
I don't even know if that needs to be in that. That's. Let's see, let's go for my notes and see. I don't have anything else. So. Yeah. We'll hear from Dig at 10 or 10:15, and then unless we get any other amendment requests from the committee, then I think we'll be ready to vote probably tomorrow, just to make sure that everything is squared away. Anything else for you?
Running out for me.
Anything, Michelle?
No, I did just have a question, just back to
Yeah.
the earlier amendment on HRC. I was just wondering, would it be possible for committee members just to have a copy of the statute around the jurisdiction for HRC around what types of civil rights complaints they hear? I guess I was just listening to kind of like who might be involved in these particular pieces.
Yeah, that could be helpful.
Okay.
Thanks. All right. That's 7:72 at 9:45, and Cameron, I assume, is coming. So we can adjourn until, or I'm sorry, recess until 9:45.